As we mentioned, the U.S. Supreme Court today did have oral arguments on that case involving Donald Trump and the Colorado Supreme Court. Of course, the Colorado Supreme Court deciding to keep Trump off the ballot in that state. There is so much to go through regarding today's hearing and what was said, what was not said, and the discussions therein. Joining us now for an overview of what happened, we welcome Stephen Montoya, attorney from Montoya, Lucero, and Pastor, and our good friend Paul Bender from the ASU Law College. Gentlemen, good to have you both here. Thank you so much for joining us. Paul, let's start with you, Paul, since you're waiting on us out there. Your thoughts from what you heard today on this case?
Well, it seems pretty clear to me, and I think it's the right answer, that Trump is going to be put back on the ballot in Colorado, that the 14th Amendment does not exclude him from the ballot. And the reason for that, in my mind, is the 14th Amendment, it sets a qualification for ballot, like, you have to be 35 years old to be president, but it's not the usual kind of qualification. Qualification here is that you didn't commit insurrection against the United States. That's a crime. And I think you need to have a determination of whether he committed the crime before you keep him from the ballot. And there's a way to do that because it's a federal crime to commit insurrection. So he can be charged with that, he can be prosecuted, he can be convicted. And I think what the 14th Amendment means that if you're convicted of creating an insurrection against the United States, then you can't serve as president. If you don't do that, then you have to leave it up to the 50 states. There's 50 different presidential elections, one in each state, to pick the electors. And you're going to have 50 states trying to decide whether he committed an insurrection. Some will decide one way, some will decide the other way. You won't know what's going on. The easy thing, and I think the thing that the framers of the 14th Amendment must have meant was, if you're convicted of committing an insurrection, then we know it's a federal conviction, it's affirmed by the Supreme Court, then you're excluded from the ballot. But that hasn't happened to Trump.
And Stephen, we've talked about this in a variety of ways over the months here, and the idea of how much proof is needed that he was involved in the insurrection, and is a conviction needed? Paul says yes. What say you?
I say no. Insurrection wasn't a crime in the Civil War period when Section 3 was drafted and ratified in 1868. So the framers were not looking to see whether or not someone had been convicted of a crime. In fact, if you read the legislative history, they actually rule that out. But I do agree with Paul substantively. You can still consider whether or not he engaged in insurrection, because insurrection was a common law crime, not a statutory crime, and it was defined by Blackstone and others. And that issue could be submitted to a jury, but I don't think it has to be submitted in a criminal proceeding. It could be submitted in another type of proceeding, but I don't think that proceeding could be an administrative proceeding before a state secretary of state or before a state trial judge in a quasi-administrative proceeding, which is what took place in Colorado. I think it would have to be a traditional legal proceeding, and I think there'd have to be witnesses, there'd have to be discovery, confrontation of accusers and such. That did not happen in this case. So ultimately, I do agree with Paul that I do think that Trump was an insurrectionist, but I do think that you have to follow the law, and I do think that he has to have a proper trial, not a criminal trial, but a civil trial, and that didn't happen in this case.
Paul.
Yeah, well, I agree with most of what Steve says, but I do think since it's a crime, it was a crime then, is a crime now, you're going to keep somebody from the ballot for committing a federal crime, the burden of proof should be beyond a reasonable doubt rather than just more likely than not. And I think that's really important. So if you want to keep him off the ballot, you have to have a proceeding where you hold that he committed insurrection beyond a reasonable doubt. That could be a criminal proceeding. It could be a made-up civil proceeding. I think the framers of the 14th Amendment said, we want to keep these people off the ballot, but which people do they want to keep off the ballot? The insurrectionists. How do we pick the insurrectionists? We have to prosecute them. Otherwise, we don't know that they're insurrectionists.
Yeah,
so I think we prosecute them in order to keep them off the ballot.
As a matter of fact, Congress passed another bill. It's called the First Enforcement Act in 1870, and it created it created a law that required United States attorneys to bring quo warranto actions in the federal court to kick people out of office that they believed were holding office in violation of Section 3 of the 14th Amendment. And they were not criminal proceedings, they were equitable proceedings that proceeded under the old equitable writs, and they were kicked off the ballot by federal judges. However, all of that ended in 1872, because in 1872, Congress passed another act called the Amnesty Act that really made all of this a dead letter. A lot of it was already a dead letter because Andrew Johnson had pardoned so many Confederates that were running for office that the scope of Section 3 was really limited.
Yeah, and Paul, regarding dead letter, dead fish, call it what you want. If the 14th Amendment and the insurrection clause doesn't apply in this case, what does it apply to? Are you saying you do need prosecution, you do need proof, you can't just say, this is what we think, X, Y, Z?
Are you asking me, Ted?
I am, yes, Paul.
Yeah, somebody's going to decide whether you committed an insurrection. And that should be a legal proceeding with a burden of proof where somebody has to prove you committed an insurrection. That's not an easy question. It has to be a trial. I think one way to do that is to have a federal criminal proceeding. It's a federal crime now. He can be charged with a federal crime of committing an insurrection. If you convict him, then he's off the ballot. If you can't convict him then, how can you say he's an insurrectionist? I mean, because you saw it on television? You have to have a proceeding to do that.
Yeah.
And most likely proceeding to me is a federal criminal proceeding. If that's not going to work, Congress could establish a civil proceeding to do the same thing.
From the questions, Stephen, from the questions from the justices, what did you gather? Where were they going, and how are they getting there?
I think they were saying the 14th Amendment was meant to take power away from the states, not to give each state a little fiefdom that could kick people off the ballots willy-nilly. And even though you could apply the insurrection clause of Section 3, you'd have to do it in a uniform way that would apply to the nation as a whole. And in order to do that, I think you need a statute. And that's why I think under Section 5, Congress would have to create a statute that created a standardized procedure that could be applied nationwide, which is what they did in 1870 in the First Enforcement Act that I was referring to.
Yeah. And Paul, from what you heard from today's questions from the justices, where were they going, and what were they angling at, do you think?
I think they're angling in the direction that Stephen was just going in, that Trump is going to stay on the ballot because there has not been an authoritative decision that he was an insurrectionist. And the Constitution says that insurrectionists can't be on the ballot. But the way you tell somebody's an insurrectionist, you have to have some kind of proceeding, whether it's civil or criminal or whatever the burden of proof is. There has to be something where you charge, you get a chance to defend yourself, you have your normal rights of a criminal defendant or a civil defendant. That hasn't happened here. So I don't think you can take him off unless you can say he's an insurrectionist. I don't think you can say he's an insurrectionist unless you prosecute him or sue him for being an insurrectionist. Nobody's done that yet.
Yeah, as far as a time frame now, what is the Supreme Court going to do? What's next here, Stephen?
What's next is it's over. The Supreme Court's, the Colorado Supreme Court's opinion is reversed and vacated and means nothing. Trump will go on the ballot in Colorado. He'll go on the ballot in Maine. And I think this whole issue is done. Unless Congress resurrects the issue by passing a statute, which is never going to happen. And by a statute, I mean passes something pursuant to Section 5 to enforce Section 3. Section 5 of the 14th Amendment enables Congress to pass legislation to effectuate Section 3 and the other sections of the 14th Amendment.
Right.
I don't think that's going to happen. So I think I agree with Paul. This is going to go to the electorate in November.
30 seconds left, Paul. Is this it for the Supreme Court? You think, what kind of timetable before they make their decision?
I agree with Stephen entirely. The Colorado Supreme Court had no business throwing him off the ballot under the 14th Amendment because he hasn't been declared authoritatively to be an insurrectionist. Congress can cure that by setting up a procedure if it wants to. I think any U.S. attorney could cure that by prosecuting him for doing it. Neither of those things is going to happen, and therefore this is over.
All right, gentlemen, great discussion. Good to have you both here. We really appreciate it. Thank you so much.
Thank you.